By the way, to clarify, if you need to question, am I legally capable of being able to rent out said space without having to have an unconscionable workaround needing to be done in order to be within legal compliance? You are not in legal compliance, all right? So, like, for example, if you rent out downstairs, all right, while wanting to claim the person owes you rent and everything, while simultaneously the person says, hey, so, um, there's no shower down here. Ultimately, a judge determining the conscionability or the livability of said space is going to ask, do they have any way of being able to maintain daily hygiene? If you answer yes, understand if the follow-up question is, is the person able to maintain daily hygiene without needing to request access to the location of where they would need to go shower? You know, is it within their reach at any point in time, any given hour of the day or night? If the answer to that one is no, then ultimately you are in code violation. And ultimately, tenants' rights kick in, and the tenant is legally allowed to withhold rent until you remedy the situation. All right? If you are not having a shower built in their area to justify the amount of rent that you are charging, and saying that you are charging so much because of the inconvenience of them having to use your shower because you want to upcharge them on rent while simultaneously not filing following the code violations or fixing the code violation of there not being a shower to be able to daily engage in hygienic standards that society would deem as the bare minimum. So, you don't want this to go to court. Because understand, trying to claim I will do whatever I can to price gouge you on rent while simultaneously threatening your freedom and prosecution, which, by the way, unless you are a prosecutor, you cannot leverage that quote unquote threat, especially with trying to claim that your claim for back owed rent is conscionable while simultaneously not wanting to answer how a zoning, violation as big as, accommodations and amenities to basic hygiene, not wanting to answer that one. Understand you don't want to handle this situation in front of a judge sworn under oath. Because the first thing that the judge is going to ask is, regardless of the amount in arrears that you're claiming, have you remedied the zoning violation of not having anywhere for the person that you want to make your tenant or claim that owes money because of tenancy while they made a complaint, a legitimate, valid complaint about a zoning violation that you are actively engaged in by not having a shower or a bath or anything in the downstairs apartment. All right? Because understand, calling it an apartment or a duplex or a co-op, understand it doesn't matter what fancy phrasing you try to paint it up for. The courts are going to view it as unconscionable and housing discrimination because they're going to end up asking, why is it that this person should have to pay an upcharge and subscription fee to be able to, be able to meet the daily function, of hygiene, the societally set standard of one, while you simultaneously want to act like you are in the right for charging somebody and being like, they will get to take a shower and not be publicly humiliated for their hygiene practices until they go ahead and pay the fucking ransom. Because the courts will go ahead and tell you, as the landlord, you are in zoning violation by there not being amenities that they could utilize, while simultaneously wanting to claim damages. It doesn't matter if the person is rich, poor, disabled, not disabled, whatever the case is. You cannot block their access to basic hygiene functions while simultaneously claiming they owe you money, while not wanting to fix the validity of their claim because of the factor that in order for a place to be considered and deemed legally tenable, it needs to go ahead and meet that threshold. Understand, by definition, by trying to claim upstairs and downstairs as different places, while simultaneously wanting to claim a tenant landlord, violation, you're going to need to be transparent with the court about the factor of there not being a shower down here. And the court will go ahead and tell you in front of everyone, if there's no shower, you can't rent it out. It doesn't matter that that was the claim with the last person that you wanted to find cause of eviction. It doesn't matter if they knew that was the case or not. Understand, the person that's there now, they know that's the case. They know they're legally on the high ground. They know they're in the right legally. And ultimately, the only thing that you have is stall tactics while simultaneously not wanting to explain yourself, while simultaneously wanting to have an attitude like, whose authority do I have to answer to? While simultaneously, the entirety of the legal profession in this circumstance is saying, hey, that's the judge's job. I mean, I know you may be pretty upset about the factor that you have to listen to what the judge says or not say, and ultimately you only have to follow the order if it is a legal order. Because if the judge orders you to do something that would be illegal, unconscionable, or unconstitutional, ultimately you need to disregard that order because they are not within the confines of their legal job description and where they have the authority to go ahead and adjudicate said scenario, especially because of the factor that if there's an establishment cause, to request recusal, because of blatant bias or anything like that, it is the responsibility of everybody spectating, as well as the individual that is expected to recuse themselves because of being too close to the situation, to actually do so. The way that, we go ahead and avoid the arguments about, somebody abusing their power, not abusing their power. We've got tribunals, committees, medical boards, ethic boards, a whole bunch of different mechanisms to go ahead and maintain order. All right? So, you may regret the actions that you went to go take because of the amount of a spotlight that it ended up putting to your impropriety, but that does not mean that ultimately handling it in an alternative venue while simultaneously having to expect all spectators to believe that everything is going to be fair and impartial is absolutely laughable, because by this point, with the amount that we've seen, the question that all of us that are sitting back watching, thinking within the confines of the law, trying to maintain the law, and maintain within the confines of that law, are wondering, if that's the case, then the amount of abuses of power that you've gone and witnessed, and the amount of tampering and swaying and all that you've witnessed in the process of video tampering, evidence tampering, witness tampering, how come there have not been the appropriate recusals? All right? Well, at the same time,
Why try to ignore when there were sealed depositions in a juvenile record that ended up leading an evidentiary trail to go ahead and clarify that I was not lying about the right to double jeopardy being ignored because of the factor of the substance and the base of the accusations being from when I was a fucking teenager before I got deemed a juvenile delinquent. Alright? Because ultimately, understand, adjudicating on it for a third time while trying to hide the factor that the basis of the situation stems from details from the first time that was sealed with prejudice and deemed by the Department of Justice to not be unsealable means that you wanting to instigate a situation to have to expose the material that the court deemed to be sealed, all right, as a matter of public safety. That means that this has already been determined. And ultimately, whether the determination ended up being to your liking is a whole different story. All right? But trying to reopen that while at the same time wanting to omit the details from, all legal parties involved, the factor that part of the adjudication would involve going ahead and unsealing a juvenile record that had been deemed sealed and expunged. All right? Like the court deemed it sealed and expunged due to the factor of some of the evidentiary basis, to go ahead and, prove and meet the standard of the burden of evidence and the burden of proof is within the court's filings. They have it. They have it sealed. They know what happened. They know who was telling the truth. They know who was lying. And ultimately, doesn't matter that you go ahead and try to use a few cops to pull a prank. All right? What does matter is the factor that those cops also understand if this whole situation hits a bench where I have to testify and I have to clarify that what's being weaponized against me for fucking decades is my fucking juvenile delinquent record, and ultimately somebody's wanting to re-adjudicate? Well, meantime, I've literally paid my debt to society not once, but fucking twice. Understand, at that point, the judge is going to go ahead. They're going to go and clarify that the plaintiff is in contempt of court. They're going to go ahead and go ahead and clarify the factor that the law enforcement officers that thought perceptionally that the perception would not be viewed as abuse of power and oppression of civil liberties will get held in contempt of court. All right? Me, I don't know what the hell will end up happening to me, but I'll end up having to clarify, hey, judge, so what I said was going to happen ended up happening. I've been spending the last year trying to clarify where I've been, and clarify the factor of, hey, I am literally trying to do everything in my power to not break the law, while simultaneously being told I'm not allowed to go anywhere. I'm not allowed to do anything. I'm not allowed to talk to anybody. I'm not allowed to associate with anybody. I am not allowed to have a social life. I am not allowed to have a romantic life. I'm not allowed to have a life apparently outside of this house, while simultaneously having legal orders requesting me to vacate the premises.